Welcome to Corporate Law Lab. I'm Neil Taylor, Director of the Corporate Law Center at the University of Cincinnati College of Law and co-host today of the podcast. My co-host today is Josie Allen, first-year student who has been piling up business and corporate degrees on her way to law school. And we look forward to seeing what she does in her career coming up soon. And our guest today is Carl Valenstein, who I've known for what, 20 some years now, Carl?
Plus years, absolutely.
Yeah.
Yeah.
And Carl is a partner at Morgan Lewis and Bacchius. Did I get that right?
You did. Very good.
I've
Very
always
good.
said Morgan Lewis. I don't think I've ever mentioned Mr.
Well, that's
Bacchius'
because all the
name.
law firms have shortened their names to two names. The marketing people have advised that. It's smart. Plus, Bacchus is hard to pronounce correctly, but you got it right, Neil.
Well, that's great. So you were just saying before we joined talking about the snow that you're from Michigan originally. Where'd you grow up?
So I grew up. Actually, originally I grew up born in Washington, D.C. My father's working at Walter Reed. Moved to Yellow Springs, Ohio, where he was teaching not far from you in Cincinnati, where he's teaching at Antioch College. And then we crossed over, changed football, allegiances to Ann Arbor, Michigan after a sabbatical in California. And so I grew up in Ann Arbor from middle school on. And
Okay, this is the part where the IU grad starts crowing about the fact that we now have the best football team in the country, or at least had.
kudos to you. You had to import a Cuban quarterback, but you had a great team. It was a great victory. It was a great victory.
They were all, I approached every game. People would say, "What do you think about the game?" And I just say, "I hope we don't get blown out." And they're like, "You're not going to get blown out. You beat Oregon last time." I'm like, "I know, but I just hope we don't. Look, this is a process and it works. I hope we don't get blown out. The game evolves and we're still in it. And then I start to maybe hope somewhere in the fourth quarter that we might win." So
It was a great game. Best championship game, I think, for a long time.
for sure. Okay, so I do have a Notre Dame grad coming up soon, and I'm going to be less kind to him since Marcus Freeman picked my in the pregame. Plus, to be able to say to a Notre Dame grad, why did you choose to go to the school with the second best football program in Indiana is going to be a good time. So luckily, we won't publish this episode before he's not prepared for that going in. So you went to then Yale undergrad, right?
I went to Yale undergrad. Yes.
What'd you major
Exactly.
in?
I was a combined political science history major. Started out as an English major, decided that that was not for me, um, and thought I was. So I kind of specialized in U.S. diplomatic history, and thought I would become a diplomat actually, and did an interesting internship after Yale, doing human rights work in the tail end of the Carter administration, and working on the Argentine and Brazilian desks when the military was in power and we were trying to get people out of prison that they didn't want to acknowledge they had. In some cases successful, in other cases not. A lot of, desaparecidos and other problems there. But an interesting time. It's when we had a human rights policy, which of course we don't any longer. So that's a long time ago now.
Yeah, we're now at the strong do what they will, weak do what they must as a policy.
That's right. I actually gave a talk on our trade policy, and I put up four political cartoons from Thomas Nast. One was Andrew Jackson stomping on the Constitution. The second was William McKinley and his tariff battle. The third was Teddy Roosevelt, speak softly, although this president doesn't speak softly, and carry a big stick. And the fourth was Monroe, and keep all those Europeans out of our hemisphere. And that really kind of sums it up. It's a very interesting time in the last 12 months. We've gone back to almost a 19th century mercantilist, imperialist, foreign policy where no more USAID, no more, moving for democracy abroad, and it's all about making money and putting America first. It's whiplash for some of us who subscribe to the old international world order.
I'm smiling as you say that, and I just, you don't know what else to do, but just kind of smile and nod and go, okay. You mentioned the human rights work and you were working with Brazil, Argentina. I know from working together that you consider yourself fluent in Spanish, right?
Yeah, fluent in Spanish and Portuguese. Yeah, I've worked for many years in Latin America, which is where I thought I was going to do diplomatic service. And then, Carter lost, Reagan got elected, and I was looking at graduate school, and my father said, "Have you thought about law school?" I said, "No, but you're bugging me, and so I'll apply to Michigan, early admission. We'll see what happens." The rest is history. I've never looked back.
So how did you go straight through, or you had a year in between then, right? Where
I
you
had a year. I had a year where I worked in the State Department doing an internship, and then I actually worked at a special ed camp. Working with um, uh, kids, special needs, kids, which was an interesting experience. But the choice was between going to law school and going to like SICE or Tufts and kind of waiting for a new administration to come in and go back into the foreign service or some sort of a, international economic or international diplomatic kind of career.
how did do you think that that year in between impacted how you handled law school? I mean, I had 2 years out. I wasn't doing anything nearly as
I'm
well.
a big believer in Josie. It sounds like you've had a gap year. Is that right?
I didn't actually. I graduated early in three, and then got my master's in that fourth year, and then went
Oh
straight.
wow. Okay. I'm well then. All right. I was going to compliment you on doing what you didn't do, but what I found because I've been teaching at Michigan Law School in the clinic and NYU for over 10 years now. I find that the students that have worked in for a couple of years, particularly when you're doing transactional work, have a better sense of how the real world functions. Not that you guys aren't smart, but it's all theoretical for you. And I think there's nothing like having some real world experience to understand how jobs work and bureaucracies work because you don't get it intellectually, you get it, but you haven't experienced how they function. And that's so impactful on how, law is practiced and, how we give advice to clients. And so I'm a big believer get years are important. And also because I think law school is a ton of work. It's not without risks. It's very expensive, and I think people should not. In my day, it was English and history majors defaulted into going to law school, and then woke up, after they paid off their student loans, saying, "This is not what I want to be doing with my life."
Right.
I've had a different career, and I'm still doing it after 43 years, and I can't imagine another profession. We'll talk more about that, but I think that getting out in the real world or even working as a legal assistant and really seeing how law is practiced, very valuable due diligence. It's a lot easier to do due diligence on graduate school and your return on investment than it was back in the day. We did a lot of things just out of conventional thinking and force of habit.
Go
I
ahead.
think my time as a business consultant, and then I'm currently data analyst for JLL, is just coming into law school, having that outside knowledge. I think is part of the reason I've been so successful this last semester.
So you worked as a consultant, so you've had a taste of, real work. It hasn't been a pure academic career. So that's my point. I find far and away that people get more out of it, and it's easier for them to follow, particularly for doing transactional work, which is only a part of what law school does, maybe a small part.
We're
Then
working on
people
making it
have it.
bigger.
Yeah, we are. We're all working to make it bigger. Yeah, I know.
Yeah, I mean, for me, I mean, I didn't do anything as interesting as work in the State Department or even as a consultant. I was selling windows and doors as an inside salesperson. But the different, there was such a step change in the amount of work between undergrad and law school. And I loved law school, liked everything about it, but it was still
Yeah,
a lot of work. And
Mhm.
for me, having been going to work every day for a couple of years in between, it wasn't such a huge, oh my God, I'm now drinking from a fire hose.
Yeah.
It was a lot more easy to go, oh, I can do this. I just have to do it, 12 hours a day instead of 8.
right.
So what do you remember most about your time in law school? Any experiences like, clinics, journals, whatever? What was your favorite part of law school that you still look back on?
Yeah, so remember, this is ancient history now. We're going back 43 years. It's hard for my students to understand a pre-internet world
Yeah, I
where
was
you had
just
to go
explaining to Josie
you
about
had to
how,
go to the stacks.
yeah,
Josie doesn't even know what the stacks are. They're not virtual stacks. You actually had to find books in the library on the shelf and negotiate the time when it was open to actually do your work. So look, I loved everything about it, and it may have been the culture at the school because not everyone has had a positive experience. I've heard from friends, and I made a decision. I had gone east. I thought about staying on the East Coast and doing, the Harvard Yale thing. Michigan had a great, I knew had an interest in international. Michigan had a great international faculty. But I have to be honest, paying in-state tuition and being able to live at home and not starting my career massively in debt also appealed to me. And I thought, top five, I think Michigan was top five at the time. I said, why? This is like a perfect choice for me. And I've heard good things about the culture there, et cetera, and I loved it. And honestly, I stacked my education against anyone else. Though I just found everything interesting. And if you look at my career trajectory, you can say I still haven't made up my mind what I want to practice because in different decades I've done different things, and that's what's made it so interesting and why I really have enjoyed working in a private firm and not in-house for one client is because I get multiple clients,
Mm.
different industries, different issues, different styles of practicing, and I get to work with super smart colleagues. That if you go in-house too early, you lose that opportunity to network. And I've had opportunities to go in-house, and it's funny, I've just stayed in a law firm. Didn't feel, I needed to go in-house or go into government because I just liked the independence and I liked the variety of the work and being surrounded by super smart people and liking the clients and all of that. But it's not for everybody. I mean, in counseling young lawyers, some people after 3 or 4 years, they feel they're in a rut. It's not what they want to do. But there are huge opportunities to use your legal degree in business and in other things. It's extremely valuable degree. So I honestly thought, I came out with a lot less debt than students now. I don't tell them how much because they hate me. It was a different time, but starting salaries were $30,000 a year, not 220 or $230,000 a year in big law. Um, but I thought I'd last 3 years maximum and then maybe go work in the State Department Legal Advisor's Office. Here I am 43 years later. I mean, I did not expect to survive big law this long.
So, did you know going into Michigan that you thought you wanted to do transactional practice, or did it occur to you
Not
while you were there, and how did that occur to you?
Actually, not at all. It's funny. I gravitated toward trial practice. I love, arguments. I love writing briefs. I did Jessup, international moot court competition. I loved it, testing your mettle on your feet, in court. And I took trial practice, whatever. I actually did not think that. And then I took some trade classes. We had John Jackson, the god of GAD and the WTO is not with
Yeah.
us anymore. And the WTO may not be with us for much longer, but the way we're going. And I thought I wanted to do that practice. So, I ended up going to DC where to Aaron Fox, which at that time had a unique international department where you could do trade work, Washington policy work. You could also, they had some New York partners that were doing transactional work in maritime and a few other industries. And so it was a nice mix. I call it almost like a European law firm where you get to do a little of everything, which doesn't exist today. And I made a choice of doing that because I wanted the variety. And I didn't really get to be a transactional, a lawyer. And I would say that I'm a dominant transactional lawyer, but I do a lot of other things. I do a lot of compliance and trade work. We can talk about that. And that's the value of having that mix in Washington. I really didn't decide. And some, as I said earlier, some say I still haven't decided when you look at how many different things I do until much later. And I found that trade work, doing anti-dumping countervailing duty cases was a counting exercise and not what I wanted to do. But very intellectually interesting to study academically, but not to practice. And that's another thing that you realize, and Josie, you need to, think about things that are interesting in law school are not necessarily what you want to end up practicing. People ask me, well, what courses should I take, to do this? And I say, what you should take is the most interesting courses with the most interesting professors. This is your time, in law school to really have an opportunity to get a great education. What you will learn is how to teach yourself to practice law. And of course, the law firms will help you to fill in the gaps because we all have training programs for young lawyers. But you're never going to have this time again to explore knowledge in an academic setting and pursue your own interests. And it's a lot harder in a firm, although I'm a big advocate of people, taking ownership of their practice and being intentional about what they do in a law firm. Yeah, you have to bill hours and you have to keep certain partners happy, but that doesn't mean you're an indentured servant and can't try to take control of your practice and develop. And we can talk a little bit more about that.
Yeah, I mean, what you mentioned wanting to be a litigator, as you know, I started as a litigator, and I remember when I kind of made the switch to doing corporate work, it's a not terribly funny story. I did an internal investigation, and the guy that was doing deals got caught up in it, and they kind of looked at me and said, "Okay, we got 10 deals running. You're going to Australia next week." And I'm like, okay. And that guy was supposed to go, and I became a deal lawyer overnight. And I was like, but I don't know what I'm doing. And he said, look, this is the closest thing in corporate work, doing M&A to litigation. Don't
Right.
act, you're not trying to win, you're trying to get the deal done. But other than that, this is as close as you're going to get to doing corporate work that's like litigation.
And this is a problem I fear with Josie, your generation of lawyers, where given how much we're paying and the pressure for billable hours, which we had more ramp up time back in the day. There's also a pressure towards specialization. And one of the enjoyments of practicing law, and also what makes Neil and me better counselors, is we have litigation experience and we have deal experience. And I'll give you, I actually, I went the other way. So I ended up litigating a busted maritime deal. We did a cruise line financing in Hawaii. Of course, it was in Hawaii, so I wasn't going to let the litigators handle this case. But I ended up litigating the lift stay in the bankruptcy court, the arrest and foreclosure of the vessel, and then auction of it, and then the litigation over lien priorities. And these were over documents that I had negotiated, which is also a very humbling experience because deal lawyers get very arrogant that they're great draftsmen or women and that everything they draft is very clear. And what you realize very quickly is when you go back to look at something in the dispute, it's not as clear as you thought it was. And good litigators can make anything you think is black and white into gray. And it's actually fundamentally changed the way I negotiate and draft because I sometimes can't win a point, but I can create strategic ambiguity that I know will be useful later on. And you also can counsel clients better because, when there's a problem, and I've experienced this recently where a corporate lawyer with no litigation experience said, well, we'll just go into court and on this specific performance clause and we'll get a judgment right away. I said, that's not how it works. And have you actually looked at the case law on specific performance in New York, what you have to prove? And so I'm afraid that the experience, Neil, you had and I had being able to have a more diverse practice, given the pressures on you guys now, is not going to be available. And I think something is lost because where we add value and where we ultimately will stay ahead of artificial intelligence, which will change the way we practice, is by strategic advisory work. You want to move up the food chain to that kind of counseling work, and you need a broader scope of practice. Now, you can do it in a narrow area, and some people stay in a narrow area, and they can become strategic advisors. For example, in IP or tax, you don't need to be as broad as us. But in other areas, the broader you are, the more interesting the practice. It certainly explains my longevity working for big law. If I didn't have that variety, I would have done something else. I mean, I need the intellectual stimulation, the challenge.
Yeah, Josie, I'm going to let you in just a second. Just one more point. I think I used to say to people, because when I was managing the legal department and the contracts department at Avnet, had I would sometimes try to get people to make the leap from one to the other. And sometimes it was just putting a square peg in a round hole. And I remember having a conversation with one of my friends who was an immigration lawyer. And I said, geez, Chris, how do you do this every day? H-1B, L-1A, L-1B, labor condition application. Doesn't every day seem like the one before it? And he said, I really like being an expert in what I'm doing.
Right,
He's like,
right.
he's like, when I was in private practice, in a more general practice, I found it so anxiety inducing that I didn't feel like an expert every
Right.
day, and now I
That's
do.
right.
And he says, I couldn't do what you do, and he's a great lawyer at what he does. But that was just the way he looked at it. And I think he's right. There are some people like you and me that
Absolutely.
gravitate toward the variety, and there's some people that need to be experts, and we need them to be
Yeah,
experts.
no, you're making a great point. And when I've talked to students, not everybody likes the challenge and likes having something new. The value of expertise, that's a comfort zone. And by the way, all of us have made it in practice have specializations and we have expertise. I know the minutia of Cuban sanctions or Russian sanctions like nobody else, but that's not all I do.
Yeah.
I can do an M&A transaction and I can at least advise clients on what an arbitration or litigation looks like. But there are people that feel more comfortable staying in a narrow lane and that's fine. Everybody has to find their own way. Mark Twain, my favorite writers, says you can't get to the 70 following somebody else's path. My path might kill you. And it's very, very. I'm paraphrasing. He said it a lot better. It's very, very true. I have friends who are excellent lawyers, and they have a narrow IP specialization, a tax, and you're right, Neil. We need them because us generalists, we're good at framing issues, but we actually need at some point an expert who can get the answer and know exactly where to look. And so we need all of those people. And you have to actually figure out where you're comfortable. And this is an individual lawyer thing. And it's same with negotiation styles or styles of practicing. Josie, I mentor a lot of young women my style is more consensus building and less testosterone driven, New York aggression. There are lawyers who do that. But I've said to a lot of the women that I mentor, you have to develop a voice and a style that you're comfortable with. It needs to be effective, but there
Mhm.
isn't one way to practice law.
Oh, 100%. No, it's very diverse. I completely agree. And I think I've also heard a lot that law school teaches you how to think like a lawyer, not do the law. So I do think, especially now in today's legal sphere or sector, law firms are using the summer associate positions. That's kind of where you get like your differentiating practice. They're doing a lot of pool work, so everyone puts all of their work in a pool, and then you get to choose what kind of stuff you want to take on. Although that's only 2 summers, and then you're exactly right. They kind of start to funnel you. You start to take, more and more from one partner, and then you kind of find yourself into a specialty.
Some firms have a rotation. There are fewer and fewer because more firms, you're right, are hiring now into a department. But
Mhm.
within a department, by the way, there are a lot of different things. So I used to run the corporate department in Boston. There's a huge difference between doing venture capital work, doing private company M&A versus public company M&A versus doing securities work. They're all in corporate, but
Yeah.
they're radically different areas of practice. I encourage young lawyers not to define themselves narrowly, but some want to feel that comfort from expertise and they end up doing just venture capital work. And then I've got some people who want to do just M&A and don't want to do venture capital work. And I say, well, isn't that silly? What if you're representing a public company buying an early stage venture?
Yeah.
Well, if you don't know what the NVCA documents look like and what, part of the alphabet they're in fundraising, and how they think because it's radically different from a big corporation, you're not as effective. And so what I'm finding is, and maybe you can comment on this, although I suppose you're supposed to be interviewing me rather than me interviewing you, but this is more interesting conversation. I'm finding more and more young lawyers wanting to define themselves too narrowly, too quickly. And that concerns me, and I'm not sure why that is. Is it a feeling of comfort, of expertise, or are they sure because a lot of us don't know what it is we want to do eventually, but also don't realize that you're limiting yourself and ultimately survival in big law is staying busy and staying in demand.
Yeah.
And you need a diverse set of skills to actually do that. The reason I have a diverse practice in part is called surviving 4 recessions and learning to diversify to hedge risk.
I think you hit it right on the head. It's supply and demand. I think as partners age out, They're looking for, a young associate to take over the practice. And a lot of attorneys that I've spoken to this day, I ask, oh, how did you get into the construction group? Or how did you get into the employment benefits group? And they're like, kind of just fell into my lap because when I was a young associate, an older partner was looking to offload work and I just kept taking more and they were great mentors. And I think it just happens in a natural way. It's just supply and demand, honestly. There's a demand that needs to be filled and a supply.
Yeah, you said something that's really important, that you like the mentors. What I've said, and this is why I say to people, you have to be open to opportunities and be opportunistic. What defines your happiness as a young lawyer are the people that you work for, your immediate supervisors, whether it's a senior associate, partner, whatever. And you might find that the area of practice is something you never in a million years would have thought you wanted to do, but you like the group. There's great training, there's great mentoring, and they actually make it all very interesting. And that's my point about what may be interesting academically or in law school. It may not be interesting in practice, or may not be an interesting practice where you are in a firm or a company. And so you always have to be thinking about, okay, is this what I want to do? Is this the best use of my time? What is the career trajectory for this? I had a student call me up and said, I wanted to do M&A, but I got in this aviation finance group and I love the people and it's really interesting. I said, go with it. It's great practice and it's very much in demand. It's a smart strategic move. Don't look back and second guess, that decision.
Yeah, I mean, I think we do a disservice if we tell the people that are unhappy that they're missing that are happy that they're missing something, right? If you're in a practice area and you really enjoy it, you like the people you're working with, don't stress about being happy so
Well,
much.
well, that's right. Because if you look at the statistics on job satisfaction with lawyers, you're in the minority. If
Exactly.
you're happy with what you're doing, there are far more people who said, "God, I thought I wanted to do this. I thought I wanted to do big M&A in a giant New York firm, and now I've done so many due diligence checklists and comparison of diligence materials, and I have yet to negotiate a contract. I'm great at disclosure schedules, but then you suddenly have an awakening and say, geez, I'd love to have a mid-market deal that I could actually do myself, and actually learn.
Rosie, that's your cue for the next question.
Okay. Well, speaking of entering the job market, where did you start practicing?
Yeah, so I commented a little bit on this. I interviewed, and I was coming out into a seller's market when the early 80s, we had come off a recession, people were hiring, the market ebbs and flows, as you know, and it's challenging now. So I could literally fall out of bed and have job offers. And I know you're going to hate me for that because that's not the way the world is now. I was strategic about this. I mentioned I have an interest in trade, public policy, but also an interest in, transactional and international. And I found this firm in DC, and part of it was the brother of a tax professor, Doug Kahn at Michigan. His brother was one of the founding partners at Aaron Fox, Kittner, Plotkin, and Kahn. And he said, "Well, have you thought about that firm?" And I said, "Not really, but I'll get smart about it." Of course, this is pre-internet, so you had to do it the old-fashioned way, which is find their brochures. It's really hard for you to imagine what it was like to do due diligence back in the day. And it was I would say this is a unique group. I could go into the corporate department at, I won't name them, a big, firm in New York or one in LA, but I'd be hyper specialized and I'd be missing out on stuff that I like. It was a good strategic move. It didn't quite have quite the cachet of the firm in New York, but I think I would have been out of that firm in New York in 5 years. And here I am. I was at Aaron Fox for 20 plus years. Great firm to grow up in. The only reason I moved, and I love the place, still love the people there, is I needed a more of an international platform. They did not have foreign offices and didn't have those capabilities that was where my practice was growing. And so I moved to a couple of firms, one voluntarily, then one was going out of business, involuntarily
In the
moved
middle of my
fortunately.
deal.
Yeah, in the middle of Neil's deal, but it was seamless, Neil. We didn't let you down.
It's true.
And
Other than having to change your email address, I honestly didn't notice that your
yeah, and
firms.
so unfortunately didn't have to to pay the trustee in bankruptcy too much money, unlike some of my colleagues. That's a subject of another day. And so, but now I'm at a great firm with hundreds of lawyers outside of the U.S. and I work with them all the time. It makes for a long day. That's the downside of doing international work. I start early with my clients in Russia, in the Mid East, and then late at night with the Asian clients. And so I've had some associates say, "We love working with you, Carl, but we like our sleep more. Your practice doesn't give us enough sleep, and we need to lead 8 hours a day. I don't get anything close to that, But that's another thing."
So what was the first deal you worked on? Was it anything memorable, anything that stood out to you?
The first deal, oh, yeah, a couple. So I was doing very interesting. We had maritime finance lawyers that had come from a New York firm, and we were doing Title 11 financing for some LNG tankers. And I got into the maritime space. I've always been a sailor, but that's a different thing than actually practicing maritime law. And I actually got my job, and it's been a super important part of my career. So I have represented not only oil tankers and barges, but major cruise lines and done more M&A involving, everybody loves that and say, well, I'll do due diligence on that cruise line. Sure, I have no problem staffing these cases, Josie. Let me tell you. But I've done, and that cutting my teeth on that and becoming an experienced maritime lawyer and a maritime transactional lawyer was valuable. It led me to a whole practice area with cruise lines. That's been a major part of I've done probably more M&A in the cruise industry than any other lawyer. And interestingly, now Trump's talking about revitalizing the maritime industry. And so those of us who understand the Jones Act and citizenship rules are very much in demand. And so it was interesting. That was my first deal. And even though I was in Washington, which is traditionally thought of where only regulatory lawyers go, this unique international group we had mixed the transactional and the regulatory. It was like perfect for me. As I say, it was almost like a European firm. That kind of firm doesn't exist anymore, unfortunately. Some people look at my resume and say, I want to do that. And I said, I don't think I could do that again. But there's still opportunities to take ownership of your practice and try to, move it in a direction that gives you some variety, if that's what you want.
Completely. Yeah. It's funny that you brought up maritime law because before you joined, Neil and I were talking about one of a fellow UC law student was interested in maritime law, and Neil, who runs the externship program, was like, "Where in Ohio do we have maritime law?" And he's so good at his job that he found a place. But yeah, I worked with SBP Law, which is actually where Neil found to pair the UC law student at, and I worked on a maritime case.
Ohio has rivers. You have maritime.
They do. They do indeed.
You have rivers that have trade on them, and there is maritime law there. And of course, I think it's funny the when you now I have the side practice of doing high net worth individuals luxury yachts, and sometimes they bring them back from Europe. I know, again, not hard to get associates to work on these things. But sometimes they document them in the U.S. So where is the National Vessel Documentation Center? Is it on the coast? No. It's in Falling Water, West Virginia, which is not near any navigable water. And that's called politics because they had a very influential senator who got that facility there. So even though, Ohio does have rivers, but it's ironic that the National Vessel Documentation Center is in Falling Water, West Virginia.
That's funny.
At least they got water in the name.
Yeah, exactly.
Exactly. It has water, but there's a Frank Lloyd Wright building, but it's kind of falling over rocks. It's not navigable water.
Transitioning later into your career, what was the first deal that you served as lead counsel on?
Yeah, so it was a maritime deal. So I was like a fifth year associate, and we were selling a interest in a cruise line to an investor. And so the partner in charge, who God knows why had confidence in me, and who said, all right, you're going to do this deal by yourself, and I thought I was going to lose it. He said, you're going to London, you got this, and we're going to send you. And so, that was really a milestone because, you can shadow partners, you can be in a support role for a while. But when you were, and remember now, this is pre-internet, you couldn't FaceTime, and get advice. You could call back, but it had to be at an arranged time. Um, you were really out there on your own. And I fortunately I did the deal, and his confidence was warranted. And I learned a ton because being in that first chair is a really important step. And and what I've learned as a teacher now is I have a lot of small deals, and some of them are pro bono. I have a whole pro bono practice on top of my regular practice in the impact investing space. And I keep a lot of these small pro bono deals, and I make sure that our young lawyers get to first chair, under my general supervision, small financing or an equity investment, a couple $100,000, because that's how you learn. You
Mm-hmm.
you learn only so much by watching and shadowing. There is something about being in the chair and being responsible. Now we have a safety net, of course. We're not going to commit malpractice. But even knowing that, there's a real value in doing that. And one of the things that people lose sight of when you go and work on these marquee big ticket deals at major New York firms is you're not going to get anywhere close to that first chair. I was laughing a little bit earlier. You'll be doing due diligence memos. You'll be doing disclosure schedules. You might get lucky and do an ancillary document, whoopee, corporate resolution. But you're not going to be negotiating the primary M&A documents for a multi-billion-dollar deal. There are associates that are 3, 4 years into this and suddenly say, "Gosh, what skills do I have?" I don't, and that's why I think in a way, a mid-market practice that has a lot of variety or an opportunity to do transactional work pro bono. The pro bono can be used as a way of filling your knowledge gaps, unless you want to do something completely outside of your comfort zone, like as I did early on, a amnesty petition, which is completely outside of my comfort zone, but that's me. But now I do transactional pro bono in the impact investing space. So I'll do impact fund formation and then all the investment deals. I represent a whole bunch of those if you look at my bio. And that generates a huge amount of interesting transactional work that associates can cut their teeth on. And they love it. They all love it. And I have a steady stream of that stuff.
Well, they're probably biting at the bit to get their hands dirty.
Yeah, no, absolutely. I mean, I've got like 20 people working on different impact funds on their deal because it's impactful. It helps people in the community. It gives, it creates, it's a win-win in terms of training as well as job satisfaction, et cetera. So it's worked out well.
So how does I mean, I was lucky, right? I had a very similar situation, but on the litigation side, where a partner grabbed me and in my first year said, "Go take that deposition. I'll watch the first one, then you're doing these other." So we had a case with, a securities malpractice case with like 15 plaintiffs, and three of them were big and 12 of them were uninteresting. Well, they were pretty interesting people. It was an infomercial investment case. And he's just like, "You're doing all the little people. I'll do the three big ones." And I remember a year later seeing somebody I'd gone to law school with who was a year ahead of me that was taking depositions with the New York firm in our conference rooms, and he was third chair. And
Right.
I didn't even know
Right.
what third chair did in a deposition, I guess arrange the exhibits.
Well, yes, exactly. Make coffee.
So, what was, if you say, what's my least favorite or hardest? I mean, I don't want you to like call out one of your clients, especially if it's me. But like, what was your hardest or least favorite deal?
I think the most challenging deal was representing a client in M&A transactions, sell side, that let's just say was not as forthcoming with disclosure issues as I felt they needed to be. And the most difficult thing to do was to sit down and the client said, "Look, if you don't disclose this issue, and I think this issue can be worked through and it will not kill the deal, I feel the need to withdraw because I can't represent you and put forward disclosure schedules, whatever." And I've fired clients before. I didn't fire this client. They came around and we got through the issue. It didn't even result in a repricing of the deal. It resulted in a little bit of delay while the other side could get its arms around the issue. But I pointed out to them that not doing that would be fraud, and we were not going to participate in fraud. And I think that's a very hard thing. I mean, I was a partner when that happened. And I tell associates, if you see anything like that, you're probably not going to feel comfortable dealing with it. But the wrong thing to do is remain silent. You have to report it up to the ladder to the partners, and the partner needs to deal with it. And in many cases, I had to go to the general counsel of the firm, get advice, etc. I think those are the hardest things to do. But your reputation as a lawyer is really your stock and trade, and we're not obligated to represent people merely because they pay their bills. There are moments when you need to fire a client or need to withdraw. Now you need to do that in a professionally appropriate way that doesn't prejudice their interests. And I've done it, and I've left money on the table, but I've slept better at night, and unfortunately, we have some examples of lawyers that have lost their moral compass and gone on the dark side, and some have even been indicted and convicted and have done time over that. But I think that's something you have to lose. And good firms will value doing the right thing. It's not all about making money, but that's hard. And I think that's a really important thing to instill in young lawyers and young partners who are desperate to bring in business, but you got to bring in the right business. The wrong business can be a problem for you for the rest of your career. You get a bad reputation, or worse, you can get in trouble.
Well, and nobody, as you know, I did a lot of compliance work myself as
Yeah.
chief ethics compliance officer and then GC of other companies. I don't think I ever ran into anybody that said, "Hey, let's commit a fraud."
Well,
You
I
know?
had another case, Neil, recently. I mean, I don't know. I hope I don't attract these people, or it's funny. I have a reputation in the firm. If it's complicated and international, call Carl. So I get brought in as an advisor. I had one deal where we were representing somebody who was raising money in the Middle East and was trying to do invest in a U.S. I won't go into specifics because I don't want anyone to know what this is, a biotech company. And we saw some documents where they were misrepresenting our advice and also using it in a way, just our involvement in the deal to raise money, and then misrepresenting to the other side that they had raised the money in order to get other money in. And we basically withdrew. But you always have to be alert to these things. If something smells or is not right, then you got to analyze it. Now, sometimes people can overreact, and young lawyers can sometimes see an issue where there isn't an issue. I love it when I'm training people to do due diligence, and the young lawyer comes and says, "My God, their certificate of incorporation has been revoked. They're not in good standing." I said, "Calm down." I said, "We can probably get that cured for a few $100s of back franchise taxes. It's not a big a problem. If, on the other hand, it turns out that the key, crown jewel of this company is intellectual property. It turns out it's owned by an inventor who has not assigned it to the company, and they no longer work for the company. That's a problem that may be a lot harder to fix." So, those are things. But I said to young lawyers, always come to me if you think there's a problem. Even if you're not sure it's a problem, come to me and I'll help you work through it. Because we always have to keep our antenna up. Just because it's a client of the firm doesn't mean they're doing the right thing or we want to continue to represent them.
Well, and if you're in-house or if you're an associate in a firm and you raise it up the chain and it is one of those issues that's not easily solvable, in my opinion, you have to leave. You know,
Yeah,
you
I mean, I've been
and
dealing
that's
with one
really
of
hard to
those.
do. And that's how I have some, I wouldn't say sympathy, but at least I understand how it happens when you have one of those come across the transom and you're like, okay, I'm going to go tell the people that need to know about this. And they're like, do you think we can get away with it? Is anybody ever really going to know? And you start having those kind
Right.
of conversations. You're like, oh God.
I've had that. It's interesting. You're right. I mean, I've also helped inside lawyers and outside lawyer be the one who says, "I'll talk to your CEO, your audit committee, and provide some cover for you," because it's hard for, as you know, in-house blowing the whistle on people that are, above you. But it is the right thing to do. And if you want to protect yourself, at some point you do need to resign. There are some people. I had an interesting case where in-house lawyer resigned and brought a whistleblower action, which she lost, and in part because she had a sense of this, there's only one way to do it right, and the company was taking an undue risk. But it was a situation where, it was a judgment call. It wasn't, Neil, what you're talking about, where
Yep.
there's clear fraud or clear,
Yep.
prevarication or something like that. If it's a judgment call, then, you got to be a little careful. Some people have a lower tolerance, and in her case, she resigned, and maybe she should have resigned because she was not being effective internally. But bringing a whistleblower action on the grounds that the company ignored her advice was a risky move, and one that was not ultimately successful. That is a very risky move because you get painted. Good luck finding a job again when if you get painted as somebody who blows the whistle prematurely. That's a tough thing to do.
Well, and you've
But
given me a
you
nice
know, it's
segue to advertising our corporate law symposium coming up on March 6th, because I'm giving the opening address, which I've decided not to call a keynote because I can't get up and thank myself for inviting myself to give the keynote.
she
And
can thank you or whatever. Get somebody
I
else.
I did have a different keynote lined up, and then when that person developed a conflict, I realized that I'd given an hour-long presentation to the faculty last year that I can rework into the opening address. But one of the things I'm going to talk about is for in-house lawyers, Model Rule 1.6, duty of confidentiality versus 8.3, duty to speak up. And it has to be really, really clear, in my opinion. And, sometimes you can reach that point where you go, I'm not comfortable working with these people. I think I'll go now. But to
The,
get
the,
to the
the,
point where you
the, the
go,
silent withdrawal, the
yeah,
quiet withdrawal is very different from a noisy withdrawal. That's a
right.
very different thing. Yeah,
Well,
and
and then,
that's an important distinction. In the cases that I mentioned, we would never have made a noisy withdrawal. And Josie, what that would mean is, you make it public that you're withdrawing, and even maybe, some lawyers feel the need to proclaim their ethics publicly in a way that throws a client under the bus. You got to be very careful about doing that. In the
Mhm.
deal where we withdrew, we just stopped answering phone calls, but we didn't, did not explain what it was, and let the client explain why we're no longer answering phone calls. Honestly, that speaks volume to another lawyer. When a firm quietly withdraws, when I see there's been a change of counsel in the middle of something, I immediately say I need to know why. I mean, was it they weren't getting paid, or was it, something else, an ethical issue? Because you know, that that can indicate it may or may not indicate a problem, but it's something that needs to be looked at. So silent or quiet withdrawals can be equally effective, and they're more respectful of confidentiality, and in some cases they're the right thing to do under the bar rules. But after all the up the ladder reporting that you need to do as a good, competent in-house lawyer.
Mhm.
for sure. Okay, we've gone down the slippery slope into the unethical. So let's get back to happy times. What's your favorite
Okay.
deal? What's the one that when you think about, you're like, wow, that was fun, or the most interesting ever?
So believe it or not, it was a pro bono project for my father-in-law. And I've done a lot of deals that I'm happy with that are interesting deals. But in terms of satisfaction, so he had a business that was raising money actually for the Susan Komen breast cancer awareness. And it was running what they were called rallies for the cure, these golf competitions that women were doing. He tried to do it, by the way, with prostate cancer, but men will never admit that they have a disease, and they were terrible at organizing something. So only the women's thing was it. And so and this is public. What I'm telling you, so I'm not revealing any confidences. But they were one of the prizes at this was Golf for Women Digest. And so it's a Condé Nast, I think, advanced communication publication. At the time, decided they wanted to buy this thing. So I helped him sell his business, and he knew nothing about, selling a business. So I put together a term sheet, and I said, well, what price do you want to put on this? And he came up with a very low number. And I said, no, no, no. I said, you can't use any valuation metrics because we don't really know how they value this increased circulation. So I said, my experience from dealing with clients is we're going to triple the price. Let them counter. He said, you're crazy. You're crazy. And we tripled the price, put the term sheet, and I also structured it as a stock purchase, so he'd get capital gains tax, and save hundreds of thousands of dollars in taxes. And I thought, okay, well, that means they're going to have to diligence this, small company, whatever. Didn't hear anything for 6 months. I'd forgotten what we put in the term sheet. They come back and say, we want to do the deal on your terms, and we're willing to close right away. So I said, we better close this deal right away. So we closed this deal, and it was great because I was able to make my in-laws give them enough money to retire comfortably on. And I said, do you want a consulting agreement to get more revenue post-close? He said, no, absolutely. I said, I want out of this. So, I was the golden son-in-law, by the way, because, having done this deal. But I
Yeah.
mean, I tripled the amount of money he would get that he got. And it was just from a job satisfaction point, there was nothing like that. And you rarely get to add value like that for I've added value by, protecting, client, getting them to closing and through all this stuff. But in terms of adding value and satisfaction and getting a deal done. It's funny that I choose that, but to this day, it's probably the most satisfying thing I did. And it was a few hours of work, and it was a great result, and everybody was happy with the result. And I'll never forget at closing. And I said to him, "How does it feel to be a millionaire?" He said, "You mean multimillionaire?" And I said, "Oh, you've learned quickly." Anyway,
So
probably not what you were expecting, Neil, but yeah, and I can talk about selling Silver Sea Cruises to Royal Caribbean. That was a great deal. But in terms of satisfaction, it was that little deal, for a family member that where I demonstrated real, added value in how we negotiated it and structured it.
Mhm.
I was not expecting you to talk about Amnet and Millicom as your favorite deal, so don't worry
But
about
that
that.
that that was a good deal.
It was a
They're
great
all
deal,
good
and
in here.
it was the strangest thing I think I've ever worked on. Because if you remember, we closed on what, like October, first couple of days of
Yeah.
October 2008, in the midst of the worst of the financial crisis.
Oh, I know. I remember that. It was like, are we going to close this deal?
Yeah.
It's just going to get delayed.
I remember one of the bankers who'd worked on it said to me, I think you're the only deal that got funded that day. And I said, by your bank? And he said, no, I think you're the
But
only deal
yeah,
over 100 million. It was like $500 million deal.
Josie, you're too young to remember this, but I mean, I landed in London the day Lehman went bankrupt, and the market just M&A just died.
Yeah.
And then suddenly, I mean, we had a lot of M&A lawyers out of business. The partners were getting busy because we were called in to do restructurings and the strategic advice. But we weren't. There were no deals to keep all the associates busy. We were sucking wind for months after
Yeah.
that. And then, the effect on law students coming out into that market, it was tragic. I mean, just timing is everything. And, those are things you can't control in life. There were a couple of years of law students coming out into the worst market we'd seen.
Yeah, I mean, we kept doing small things after that, but that was the last big swing we took during my time there that I can remember. Well, then we got a new CEO and started selling stuff.
Right, and then you ended up working in a different, an adjacent industry, but
Right.
then which was interesting. But yeah, it's interesting. That timing is everything. I mean, for example, another really interesting deal. Venezuela is very much in the news. Was I represented the developer of the third mobile telecom group, Digitel, in Venezuela. We sold it to Telecom Italia. Chavez was taking control, but not quite yet nationalizing everything at the peak of the market. We sold 80% of it, and then we had a fight over the 20% put and call, which we ended up settling later. But Telecom Italia Mobile wrote that thing off because it was basically nationalized. And then, Maduro came in and ran the country into the ground. But talk about timing being everything. If they had held on to that asset for a couple more years, it would have been worth zero.
Yeah, it's like the Millicom deal where they sold their Pakistan assets to China Mobile, and then things got a little bit dicey after that. But what what do you like most about working on deals, transactions, or you can even broaden it to what do you like most about practicing law?
I think that I like building things. Well, I enjoy, litigation and fights from time to time when, that gets my juices flowing. On balance, I like the advisory. I like putting things together. I like, structuring deals in multiple jurisdictions, dealing with different nationalities, different cross-cultural communication. The more jurisdictions, the better. And then managing, it's a difference. A domestic deal is chess. An international deal with multiple jurisdictions, as you know, Neil, is three-dimensional chess. And I just like the challenge of it. And I just like being able to manage the whole process and put it all together and actually get to a closing. And occasionally you get to add real value. People say lawyers are transactional costs. Yeah, that's sometimes that's true. But sometimes my father-in-law's example is one. I added real value. And in a lot of deals, we are able to structure things in a deal with taxes or other ways where you are actually adding commercial value, not just getting the deal done and structuring. Not in every deal, but I think good M&A lawyers, deal architects that can manage these complex things, it's challenging and you get a sense of satisfaction that you're adding value. I've done, sometimes putting together a joint venture where you're creating something new is very, I've done that in the life sciences industries and other industries is also very new because you feel like you're building something. And that's very, it gives you a sense of satisfaction. At this stage in my life, I'm doing a lot of pro bono and sort of hybrid impact investing where the benefit is not going to people who may already be wealthy, private equity or high net worth individuals, but the people who are not, enjoying the benefits of the economy. So I've set up a number of funds, impact funds in Boston and internationally for Habitat for Humanity in particular, where the beneficiaries are people at the base of the pyramid who may not be included in normal finance, whatever. That gives me a ton of satisfaction because I'm using my corporate and financial skills to benefit people who would not otherwise get the benefit. And you see how transformative this is to their businesses. So,
At least
a
one of
lot of the
those
deals I've
habitat.
made,
Yeah, go ahead.
yeah, I've made rich people richer, which, okay, is nice, but you don't get the same satisfaction as you keep a small business alive or give them an opportunity to scale and hire people. There's a satisfaction there. And I've always kept that practice alongside of my other practice. It's kind of what has been called like the rent for living. You do some things to pay the rent, and then you do other things not to compensate for the other work, but for your soul. And because you're a lawyer with a skill set, and we have an obligation to give back and pay it forward.
Yeah, I mean, I think I had another guest on the podcast who said, when asked a question like that, said, find something you're passionate about outside of what makes you money and do that too. And
That's exactly, and don't wait. The mistake people made, and because I do a lot of counseling of more senior lawyers, don't think you can. For example, I've been teaching for 10 years. I've had this impact practice. I couldn't do it when I was building my practice, but I do 400 hours of pro bono a year, which is very unusual for someone my age. But but rather than retiring or being graduated, as we call it now, because we're not really retiring, it frees me to do really impactful pro bono work that I couldn't do when I was charging. And that's kind of my second act. I can do that for a long time. And then, I'll hire the firm to do the transactional documents, et cetera. But I'm going to do the structuring and, strategic advisory work. And I can do that for another decade or two.
but you were also already a known quantity in that
Yeah.
space. If you
But
had
but that's
decided at age 65, now it's time for me to give back, people be like, okay.
well, yeah. So Neil, I tell people the time to start doing your second act is when you're doing your first act. This idea that suddenly people say, well, I'm done practicing law, I'd like to teach. You and I know that it's very hard to get teaching jobs even when you're not getting paid. you know Not everyone can do it, and so people need to actually be working on that while they're when you get to 60 or even 55. You need to start, and we now have a formal program. I was in the pilot program, um, for helping people do that. And that's also good, Josie, for you younger lawyers, because the last thing you want is a senior lawyer that can't let go, because it's a block to bringing along, you mentioned inheriting practices or bringing along younger. We have when we turn 65 in our firm, we have a conversation about what you want to do. Now I'm 60, I'll be 69 this summer, and I'm still, doing billable work, et cetera, but I'm trying to reduce the hours, partly because I just became a grandfather and I have other priorities in my life. But
Congrats.
but I want to stay active and I want to add value, but I don't want to have the time pressure. But the teaching I've been doing for a long time, and I couldn't have gotten into teaching if I just did a cold start from, right now. I wouldn't you have to build the network and you have to build the credibility as a teacher.
No,
And but we have a whole program because not enough people realize that. They suddenly wake up, they're retired, and someone says you have 365 Saturdays and you don't know how to fill your time, and that is scary. That might sound like heaven for you, but it isn't heaven for someone who's been working, at 150, 40 plus years, and my wife keeps saying you have to say no to people. And what I learned from a coach was unless it's hell yes, it's no. And I like that. That goes to your passion point. Unless it's hell yes, say no, because you're going to not really enjoy the benefits of winding down and being able to do other things.
I knew a
Other
guy
than
that retired, and I asked him what's the hardest part, and he said Mondays are really hard. And I said, because you can't go into the office. He said no, because the golf course is closed, and I don't know what else to do.
there are people that, and this goes to the point we were talking about earlier. There are people that are be very happy doing nothing but playing pickleball or golf in retirement. I'm not one of those people, and you have to be true to yourself. Right now, I'm very involved with pro bono clients dealing with the federal government messing with their lives, and that's going to unfortunately last, I hope not more than 3 years, but I just don't want to give that up. I want to make space for other things, being a grandfather, more time with the family, more traveling, whatever, while I can travel. Because, if you lose fortunately, I'm in good health, you lose your health, that window closes fast. My father lived to 99, so I've, hopefully I have good genes and, I've got time to do all that. But it's hard because, you're used to being in the front, the one in charge, and there's a bit of FOMO, fear of missing out or becoming irrelevant. I think the biggest fear that people my stage have is becoming irrelevant.
That nobody wants to answer your emails or return your calls
Because
because you're
because
not. Yeah.
social isolation and that relevance of going to the office, whatever, is really that's defines whether you have a good retirement or not. And that social engagement is really, really important. So we're emphasizing for people start in your mid 50s on what you're going to be doing. And it's healthy for the firm because you do need to let go. You do need to make space for younger lawyers to come up to give them that first chair opportunity, transition your practice. But it's really harder than I thought it was going to be.
You mentioned AI earlier. Should young law students or old law students, any law students, people starting out be terrified that AI is going to take their job? And what
I
advice
don't.
do you give to them to
Yeah,
overcome the fear and to be ready for it?
yeah, so it's coming, and I have some debate with my fellow teachers. There's some people who say, I don't want to, I think AI is terrifying. I don't want to use it in the classroom, whatever I say. I take a different view. I think one of the things we teach is the uses and abuses of AI. I think AI is here. I said, however you may feel about the ethical issues, and there are many.
Mhm.
Um, and I'll come back. It's also interesting that AI use is much more male than female. And Josie, this is an interesting thing. There are more and more women, and I understand this, are worried about AI because of privacy issues, sexualized imaging, deep fakes, discrimination in hiring. And women have been more victimized by it. And so it's very interesting how AI use skews more toward young men than women. I don't know if that's borne out in your experience, Josie. I hear much more hesitation and fear of AI from women than they do from men. But for using it in a clinic, I think first of all, it will never replace a lawyer's judgment and the strategic advisory work that we do. Now, That's comforting for us senior lawyers, but that's not to say it isn't threatening for young lawyers. So let me give you an example, because I'm having my students use it. We've given the AI a name. I said you can call it male, female, or non-binary, give it pronouns, whatever. It's part of our team. And we're going to see what it can do, and we're going to critically evaluate what it's doing, because I think that's the right way to understand what it's good at and what it's not good at in test cases. So for example, and this is an example, Josie, of what a young associate would do. So we had a term sheet from a client. And obviously you need to get clients' consent before you use AI because it's confidentiality under the bar rules. So you need to master that. The reason, by the way, and I laugh about this, the reason why it won't put lawyers out of work, it actually creates a whole new discipline for lawyers on legal issues relating to AI. So lawyers are great at creating new disciplines, new practice areas. So you can specialize now in AI law and you'll have a lot of work. So it's hardly putting those lawyers out of work. In fact, it's creating a whole new practice area. I think it will change the way we practice, but I view it more optimistically than that. But there is a dark side to it. And that is that I worry that the younger generation of lawyers will be overly reliant on it, will also get lazy in not learning how to do it another way, and will not take the time to check it because it can hallucinate, it can make mistakes. But I'll give you an example where we used it in class where I was impressed. It was a venture capital class. I was teaching students how to take a pitch deck and come up with a due diligence checklist. And I said, let's see and I thought, by the way, I said, AI can't do this. This is going to be a failure. And I'm constantly amazed at how it's improving. We uploaded it into, Chat GBT was a pro, that one of the students had paid for, so a higher level of sophistication. We uploaded the pitch deck for a startup company and said, generate a due diligence checklist for an investor in this company. And we had spent an hour with the students doing it the old-fashioned way, and we had a good list. It was impressive. Within 1 minute, it had generated a list. It had everything that we had on it. And this was a company that was doing software integration. It also had a lot of technical integration questions that I would not, because I'm not a software engineer, would not have come up with. I was wowed in that case. Similarly, we fed it a term sheet and say, oh, okay, do a due diligence, do a closing checklist and with columns for status and responsibility, whatever. Within a matter of a minute, it generated that, and it was pretty darn good. Now, Josie, that's something that as young associates do, and we build a lot of time for it. Now, clients are going to stop paying for that.
Yeah.
However, you have to check it. It's not necessarily right. I view it as a rough draft and a place to start. I've had other experiences that are not so good. I've had to try to draft clauses or draft something other than a simple agreement, like a confidentiality agreement, where it doesn't really understand which side you're on, buyer, seller. It can't yet differentiate between good clauses and bad clauses, but it's getting better. As more and more things are going in, it's getting a higher level of sophistication. So it can be very valuable in doing checklists, in generating drafts. But my fear is, Neil, I don't know to what extent you use it. I have some colleagues my age who avoid it, but now realize they need to come to terms with it because it's not going anywhere. And others who are like me, I can look at the output and say, well, that's interesting. This is good, but this is a false lead. But you, Josie, wouldn't know that. You wouldn't know that. So unsupervised use of AI without training and without also learning the old-fashioned way, I think is very dangerous. And I very much worry about the pressures you guys are under. The partner time is more scarce. So there's less in-person supervision, less mentoring, whatever. You can never rely on it. You have to check everything. And that's where lawyers have gotten into trouble, and some have been disbarred for submitting briefs where it hallucinates cases. But you can have the same problem in a transaction. If you allowed AI to draft something, it could very well not be in the client's interest, whatever. But
we'll find out 5 years later.
Yeah, that's right. But it can be, I just gave you a couple of examples where it can actually save time. Now, for a law firm, that's scary because guess what? Time is money. So how do you make up for that time? Now, I would argue that allows the associate to do more value-added work instead of checklists and whatever. Now you still have to check it. That gives you more time to draft and actually do higher end things. And my hope is that it becomes a labor saving tool. It always has to be checked, but it actually can free you to do more value added services. Because we had, for example, we had associates summarizing hundreds of agreements in due diligence so that the in-house lawyer could have a summary sheet. It's great for it to use AI for that, as long as it doesn't violate confidentiality. You don't want lawyers doing that. That's grunt work.
Right.
And it's not like your lawyers that do it are learning a whole lot about anything. I mean, I liken it to, I started as a litigator. I liken it to sitting in a file room with my dictaphone saying the next document is an April 15th, 1983 letter from Bob to Bill. Those were not formative experiences other than I knew I didn't want to do it anymore.
But my example on, like generating a due diligence checklist or
Yeah, I want to come back to that, but go ahead.
Yeah, I mean, I think it's very important that you check it and you learn how to do it. You learn to go through a document, create that. There's learning in there. And so it's an interesting experiment, but I think we have to step back and say, I don't want students doing that and not then relying on it and not understanding what they're doing. But so for example, I was having students prepare questions. We're going into a diligence on a startup company. I said, okay, I want you to write and do it the old-fashioned way. I want you to think about it and write a script of the interview questions that you're going to have when you meet this founder. Do that first, and then you can look and see what AI might do, and then maybe that will help you or not. I said, but do not simply go to AI and then suddenly rely on it because you got too busy doing something else and you didn't. That's my fear.
And it's hard when you already have the list to go, oh, that list is no good. I should have started my own. It can like lead you down the path. But when you were talking about, doing that where it started asking technical questions about the software that you wouldn't have thought about,
Yeah.
when you showed those questions to your client, did they say, "Oh, those are all great questions," or did they have to tweak some of them
Haven't gotten that far, and that so
okay,
I look at it and say, well, it looked good to me, but again, I would want that vetted by by somebody who was actually an IT engineer, because they may say this is AI slop. This doesn't
right?
mean it.
Some of it
It
may
doesn't
be
mean
great,
anything. Yeah, but it can be. My point is, it can be hit or miss.
right?
I mean, it wowed me in that case, but I've also had the opposite reaction. Where drafting was very poor. I said this cause is great for the other side. And it missed the following things that
Right,
it has it's not thinking.
right.
It's merely grabbing stuff from a large database of documents using filters.
Yeah, I mean, I've played around with it, and sometimes I will use it where I feel out of my depth. We had a prior episode where we had Jordan Blesnick on, who was for many years Carl Icahn's tax guy.
Yeah.
And the Ackman short squeeze was just too much fun because Carl called into CNBC and started insulting Bill Ackman, which if Google him, you'll find out why I find that so much fun. And I started asking the AI some technical questions about how the short squeeze played out, and it was brilliant. Except when I talked to the person that lived through it, he's like, "Yeah, that stuff, a lot of that stuff that the brilliant AI came up with didn't actually happen. It makes sense that it would have
Yeah.
happened, but it didn't."
Yeah, no, it's a hallucination. Hey, I've got to go, Josie, and I've got to go. I realize
No
I'm
problem.
actually late for
No
another call.
problem.
We went a little bit over. We could keep talking for a long time, but
Or no, we
I
could
hope
make
this
this.
is.
So let me give you a big finish then. Um, Sounds like you were a pretty happy law student, but is there anything that you were stressed about back then that you wish you hadn't been?
Oh my God, we're going back in time. I wasn't. I mean, and maybe it's so long ago that I whitewashed the whole experience. I mean, it's stressful. Let's be honest.
Yeah.
First year stressful. I ended up doing an international journal, but I wasn't going to get into law review on my grades. I did fine, but the first year was tough. I mean, there's no question about it. It's tough.
Yeah,
It's a
I was
totally new
totally
way of
stressed
thinking.
first semester about, oh my God, I'm getting no feedback. It's
Yeah,
all
I mean,
exam?
it's interesting. I mean, it's very competitive. You got a lot of stressful people, and maybe, the Michigan culture is different from, some of the pressure cooker schools, but still, there's a lot of stress, and it's a lot of intense work in a very different way from what I've been doing before. It got a lot easier in the second and third year, and I felt I'd hit my stride. My one regret is I was working too hard second semester, third year, editing a journal, and some papers by Europeans who couldn't write in English. And so that was, I had too much work to do and overloaded myself, which I'm guilty of doing. Um, and that was my one regret, that I probably should have enjoyed my last semester, and more than I did.
Same. Yeah. Right. Well, thank you so much. Sorry for going over time, but I really enjoyed it. Thanks, Josie. I think this will be a fun episode for everyone to listen to. So
All
thanks
right.
again,
Thanks very
Carl.
much. Good
All
seeing
right.
you.
Cheers.
Yep.